All right, welcome in everyone. It's the lawyer with our special guest Joe from Good Logic. It's really exciting for me to have him on. I've watched some stuff before. We talked a little bit beforehand. He's a New York litigator, which is the best kind of lawyer to talk to, in my opinion, in the trenches, doing this stuff in court, knowing what it's like. Because I see people, hating on some of these trial lawyers. It's a tough gig, man. There's a lot of pressure. There's a lot of stress going on. But Joe, thanks so much for joining me today.
My pleasure. Thank you so much for having me.
Absolutely. So we're talking Ahmaud Arbery. The verdicts came in. Um, I'm sure you knew as well, or your guesses were as well, that they were going to get the done today before Thanksgiving, before we went into a holiday weekend. I think the timing kind of set up right for when closings finished, and when we ended up getting to the verdict today. So I'll talk about what the verdict is, and then I want to get your take on if it's what you expected and whether or not you agree with it, which could obviously be two different things. But for Travis McMichael, guilty on all counts: malice, murder, felony murder, assault, attempt, false imprisonment, across the board guilty. Greg McMichael, not guilty for the malice murder, guilty of the felony murder, the assault, etc., etc. And then for Roddie, which is the most interesting one to me personally, not guilty on the malice murder, not guilty, I think, on the first felony murder, but then guilty on a couple counts of felony murder, not guilty on the assault with the ag assault with the shotgun, guilty with the ag assault with the car, guilty on the false imprisonment. So why don't you just start talking however you want to about this verdict, whether or not it's what you expected and what you think of it.
So the malice murder verdict was very surprising, and I'm not sure anyone can come up with any legal justification for malice murder, because malice murder implies your typical garden variety murder, where somebody hates someone, has some sort of particular motive against the victim to kill them, and goes out and kills them. That's your your garden variety murder. That's your malice murder. Felony murder, the way it works in Georgia is that you have to have an underlying predicate felony that they are found guilty of. And during the course of that felony, the victim dies. And so what might be an accident, or could be purely an accident, and that's one of the things that happens because you're engaged in a felony, because you are creating a riskier environment by engaging in that felony, you've been found guilty of that felony. We say that a death that ends up occurring, even if it's accidental and would normally be categorized as a lower level death, like a manslaughter, which might get 10 years or something like that, because you created this entire situation of a felony and made for a dangerous situation, we're going to raise that up from that accidental death up from a manslaughter to felony murder. And usually the charges and the conviction period, the sentencing is closer towards your garden variety murder, like a malice murder. So in this particular case, there were 4 different felonies that all 3 of the defendants were charged with. There were 2 different forms of assault, one with a shotgun, one with a car. Then there was false imprisonment, was a 3rd felony that they were charged with. And false imprisonment, we normally think of locking someone in a room as false imprisonment, but if you're restricting someone's path from where they can go, so that's considered a form of false imprisonment, and that's clearly what the jury felt that they were doing. And the fourth one was an attempted false imprisonment, attempted criminal activity. So as you so adroitly pointed out, the Travis McMichael, who's the son and was the shooter, the one who was holding the gun at the time that Arbery died, he was convicted on all counts. It's difficult to understand, based on the evidence that was presented at trial, why any of them should have been found guilty of malice murder. It doesn't seem as if any of them went out there predetermined, we're going to kill this guy. They definitely went out there hunting him down. Their own testimony admits to that. They definitely were trying to catch him. And I walked into this trial, and I sort of approached the law where I'm very fixated on what are the legal ramifications, and then I'll sort of look at the social ramifications and morality, which is not always, in my mind, consistent with what the law is. but we have to deal with really both realities. So I'll always try to fixate on this is the law and this is, social ramifications or morality and things of that nature. And I'll tell you that I was easier able to define in my own mind. It felt like they were morally culpable, that I felt like this was a foreseeable outgrowth of the activity that they were engaging in. And yet at the same time, I was unsure when the trial started whether they were legally culpable. And especially if you heard opening arguments, which I sat through in the beginning part of the trial. I was actually covering it very intensely when Rittenhouse started heating up. So I transitioned over to Nick Recator's stream a bunch with several other attorneys and really locked in there. But the arguments that were made by defense counsel, which 2 out of 3 attorneys argued at that point, the third one opted to wait till after the state closed their case in chief and present their opening statement at that point. But I thought the arguments that they made were really very interesting. And they painted a picture that the world had never seen. And this is one of the interesting things about trial, is that we all just knew Travis McMichael as this guy in the pictures from grainy video or images of him covered in blood, Arbery's blood, really. And didn't really know anything about his story, why they killed them. To many people, they looked like the prototypical Southern racist, and that's certainly how they were portrayed in the media, as if they were basically labeled as murderers who were killing this guy for the crime of jogging while black in their neighborhood, and they just weren't going to have it. If you read most of the coverage in the news in typical mainstream media, that was the tone, that they basically were hunting this guy for jogging while black, and that they were trying to come up with some sort of explanation to justify that. I'm rambling on and on here. If you want to interject at any point, by the way.
No, I always find it interesting how people, especially lawyers, go into these cases in the media, and we're realizing that we try our own cases. The media only knows a small fraction of a percent of what actually is the evidence in the case, and that's basically what you're talking about now.
Correct. And I'll tell you that. So that was the image that the public at large had of these defendants. The more the more we learned about it, some people started having questions. Was he really a jogger? There was all sorts of, was he really out for a jog, or what was the story? And the story that the defense counsel told was somewhat compelling, as they describe a series of events over a period of 6 to 8 weeks, maybe even a little longer, that Arbery kept coming back to this house, and that was under construction, and he kept coming back in there and poking around, and that when he was poking around, that there was concerns that he was casing the place, and that word had spread around the neighborhood, and they had tried calling the police multiple times to catch this guy while he was trying to burglarize this house, and that every time they tried getting them, it would take minutes for the cops to get there, and he would get away in seconds. And as the defense counsel stated, in a world where seconds matter, minutes are a lifetime away. So, or something to that effect. So you sort of get this vision of a community that's working together trying to catch this guy because he's a burglar. And in fact, the defense counsel, I think his name is Rob Rubin, when he got up there and he described a meeting, the last meeting before the date of the incident, that there was actually a face-to-face moment between Arbery and Travis McMichael, where Travis was like, say, "Hey, what are you doing here?" And that Arbery actually reached into his waistband as if they had a gun. And he uses that as justification for why on the day in question, they grabbed a gun, because they were concerned that he was armed. And they were concerned that they're going to come up against the guy who's going to pull a gun on them. And that's why, on the day in question, what happens in short is he comes out of the house yet again, and a member of the posse gives this arm motion like that to Gregory McMichael, the father. The father's working in the back of his truck. He sees Arbery dart by, and what turns out is that Arbery had come out of the house, saw this other individual. I forgot his name off the top of my head right now, and he took a picture of Arbery. Arbery freaked out. I think he was actually under parole, although there's no way the defendants would have known this at the time. But he darted, And when he takes off, he runs right past Gregory McMichael working on his truck. Greg McMichael comes into his house and says, Travis, he's here. Let's go. He doesn't have to say there's a black guy here, the jogger's here. It's been so pervasive in their minds that this is like a communal effort to try and catch Arbery. They just have to say he's here. And Travis grabs his shotgun. He's like, now we're finally going to catch him. And William Roddie Bryan, his nickname is Roddie, ends up joining into the fray as far as trying to catch them. And they describe it much less as a Dukes of Hazzard kind of car chase type of thing, and more as if they're positioning themselves on the outside of the neighborhood to keep him from being able to escape before the police come. Then they call the police when in the middle of the chase, and essentially, it seems as if it's a viable. They're presenting a viable citizen's arrest claim here. There was no way the cops were ever going to catch him.
So let me ask. So with the quotes with, when seconds, whatever, the quotes where seconds are too long or minutes are too long, seconds matter, whatever it was that he said. So what was your perspective of that, legally speaking, when, yes, we're talking about a neighborhood, maybe looking out for each other, they're trying to protect their property, blah, blah, blah. But in reality, grabbing your shotguns, getting your trucks, and driving towards an individual is overkill, for lack of a better word, in my opinion. Do you agree with that?
Many people would say that, and I will point out that if you're living in Georgia in the wake of this case, and because of this case, Georgia legislature changed the law dramatically, so dramatically that it's actually kind of shocking how much they dialed back the rights of citizens to engage in self-defense. In fact, I think it's a worthwhile mention here that I had a conversation with Andrew Branco, who's the author of Law of Self-Defense, and that is his field, both with he and Nate the lawyer. And the extent to which Georgia ended up dialing back the law and the rights of citizens to even defend themselves when they're not engaged in a citizen's arrest is somewhat horrifying. But we'll get to that momentarily. So the question. So getting back to the story at hand here, you have a situation where they're trying to engage in a citizen's arrest, and under the law of Georgia at the time, they have permission to engage in a citizen's arrest, assuming they have immediate knowledge, either by vision or some other way, immediate knowledge of a legal activity that just happened, and the question as to whether or not it's probable cause or reasonable suspicion, and those are two different yardsticks. And where that lies, I've heard different attorneys debate as to, under the old Georgia statute, what it actually was supposed to be. The defense counsel ended up reasonable suspicion is a lower yardstick, meaning how much do I have to see of this guy, what he's doing that seems illegal before I have justification to try engaging in a citizen's arrest. And that yardstick of reasonable suspicion might be somewhat lower than probable cause. Probable cause, you got to really see the guy doing something shady, if not committing an outright illegal act in front of you, as opposed to somebody skulking around on a lawn somewhere that they're not supposed to be. That's perhaps reasonable suspicion, but not probable cause, if that by way of analogy here. So for all intents and purposes, all that matters is the yardstick of probable cause, because that is what the defense counsel ended up conceding to, that they had to meet that yardstick in order to have a right to engage in him. And why is it so important? You might try to fix that up.
That makes sense. That makes sense that it's probable cause, since in fact that's what law enforcement has to have to arrest. Right. So for a citizen's arrest, that's always what I've thought in a citizen's arrest, that you'd also have to have the cops have. Now the difference is most people don't know what that even means, but
that's of course, and that's part of the that is part of the problem. The reason this is so important is this: if you have a right to self-defense, well, in that case, the whole moment of engagement between Travis McMichael and Ahmaud Arbery is very different, and you can really look at it in the light of that they have a right to be doing what they are doing, and accordingly, he maintains a legitimate basis to claim self-defense and not be held accountable for Arbery's death. If they are not acting within the right and they're merely provoking him into a fight and, basically scaring the bejesus out of him, which is, if you heard the state's argument, I mean, the state, in her opening statement, she describes Arbery as spending the last 5 minutes of his life running for his life from these crazed people. He has no idea why they're coming after him. And finally, having no other option, lunging for the guy's gun, and then it goes off and he's dead. And I thought she could have portrayed it. She could have portrayed it a little bit more strongly than she did. I would have been far more dramatic in my presentation. I would have, when painting that scene, I would have actually done like heavy breathing, like so the jury can actually feel themselves in Arbery's shoes while they're being manhunted by 3 people in 2 cars. I thought that she had a really dramatic story to tell there. But that's neither here nor there. That's just a stylistic thing. At the end of the day, so these are the 2 very different narratives that we're getting. We're getting the state saying that he's running for his life, has no reason to think that he should be running for his life here, and that's how the last 5 minutes of his life, that's describing the last 5 minutes of his of terror for the end of his life, as opposed to the defense saying, look, this guy had destroyed our community. We were all really concerned. It was a safe, quiet community. And for months, we've been trying to catch him and we couldn't. And finally, when we had a chance to catch him, this whole posse that we had put together, an informal posse, but we had a posse that we put together just to try and bring him to the police so the police can deal with him. And then things went sideways. And unfortunately, he when he charged me, I had no choice and the gun went off and he's dead. Now, again, I started with a premise of saying I think that they were morally culpable because this was not something that was so far-fetched a result that they shouldn't have foreseen something like this happening. But if they are doing a legitimate citizen's arrest and he's wrestling for the gun for them, so he has a right to be there, so that Travis McMichael has a right to be there holding a gun on him because they're acting within the metes and bounds of what Georgian law allows. Well, in that case, he has a valid self-defense and all of them walk. But if they're not acting properly, they're not acting lawfully at the moment that they're cornering him in there, well, in that case, you got no self-defense and all 3 of them go to jail for a really long time. So that's why that became a really important element here. And for me, so I actually started from a position of, whether they're laying this out here, if all this holds up on evidence, I think they legally can walk. A jury can justifiably say, you know what? That's valid self-defense. Along the way, I ended up flipping into saying that they should be convicted. And the key element to me is that under testimony, Travis McMichael admitted that they had no idea what the charge was that they were arresting him for. You're going to charge him for burglary. Then what are you arresting the guy for? When you don't know why it is that you're pulling him over, you just know he's like a threat to the community. And to me, at that juncture, you're admitting you don't have probable cause. And when you don't have probable cause, everything that happens later on. So now when you're trying to corner him, that's a felony. If you're aiming a shotgun at someone, that's assault. It's a felony. Supposedly they hit him with a car also at one point. That too is a felony. All of this are different felonies. And when he ends up dead at the end of it, well, you have felony murder, and they're all and felony murder is, I think, 30 years or something like that. So that's why they are where they are.
I think it's life in Georgia for felony murder. I think it's the
Right.
same sentence as malice murder. But so a couple things just breaking down, because I do want to talk about felony murder some more too, because I've broken that down a lot on my show and how I'm not a big fan of it. So the malice murder is more into a second degree murder. In states that have first, second, third degree murder, right? It's not a intentional premeditated murder with malice aforethought, right? It's more
okay. So I'm not a criminal defense attorney. I don't want to get ahead of myself.
Okay.
I've studied criminal defense in law school. I've been restudying a lot of it over the past year because that's what comes up. I'm a YouTube content creator. This comes up a lot, and I spend a lot of time online collaborating with different people who are engaged in this, so that I never want to speak without being informed. I am familiar that in the state of New York, like the highest murder that almost anyone ever gets is murder 2. That it's only murder 1 if you kill a cop, or you show a depraved indifference to human life, and that your standard normal murder is considered murder 2. But that definitely varies from one state to another. And so yeah, I want to preface before you ask your question, just so you know you're talking to the right guy.
Sure. Yeah, I'm a criminal lawyer. So my firm's a lot of criminal law. My dad was the assistant U.S. attorney back in the day. He was the assistant of the criminal division. So we do a lot of criminal defense, but I'm in Florida, not Georgia. So what we would call malice murder, which I believe is the same in Georgia, is second-degree murder. So first-degree murder is you planned it out, you wanted to go kill this person, and you thought about it beforehand, and there's some evidence of that. Malice murder is just a depraved heart murder, which is what we call it, which is, I think, how it kind of fits to Travis McMichael, that he had the depravity in his heart, or the malice in his heart when he pulled the trigger. That's, I think, what they were going for. Whether or not that should have been guilty, I think I could listen to arguments on both sides, but I think kind of where you were going down the line, I see the felony murder falling right in line, right? With the shotgun, with the car, with the false imprisonment. To me, my biggest struggle was, before we get to talk about felony murder, was Roddie. Roddie's whole, because when I was talking about it throughout the case, I pretty much thought, once it starts to go to, in these kinds of cases, I could see guilty across the board for Travis because of how it was going, right? And once they felt like, yeah, like what you said, morally culpable, not going well for him, facts are looking bad, he didn't know why he was there, they conceded that a crime was not committed within their immediate knowledge or within their presence, it was just not looking good at that point. So that's why I kind of guessed guilty across the board for Travis. And then for Greg, pretty much guilty for what he got, similarly, because he didn't pull the trigger. But for Roddie, Roddie's being convicted of felony murder is my issue with felony murder. So what do you think? Do you think this is going to have an effect on society as far as filming things and handing it over to the cops?
Well, I think if you film yourself committing a crime, you're an idiot.
Well, he didn't probably think he was filming himself committing a crime.
Right. I mean, anyone who looks at this situation doesn't take a life lesson from this to never, ever. And that, look, I mean, I'm not telling anyone to destroy evidence, but no one had to know that he filmed that. That was a terrible mistake, which cost all of them their freedom for the rest of their lives, because this case was going to go away. Yeah, I mean, as far as giving advice to your viewers here, Nick Requeta has said many, many times, if you ever record yourself committing a crime, and he's a criminal defense attorney, if you ever record yourself committing a crime, you don't want anyone to ever see that. So think to yourself long and hard what you're doing there. But
yeah, I mean, you see,
I want to ask you a question, because you actually piqued my interest with something you said, and that is, I understand morally why Roddie is the most innocent of the three. What is the legal basis to say, purely based on law, that Gregory McMichael has any more culpability than William Roddie Bryan, when neither of them touched the shotgun, neither of them pulled the trigger, they're both involved in this exact same manhunt? For what basis, what theory is there to justify a finding that he has any more culpability than William Roddie Bryan?
So my answer to that, based on what I saw in the trial, was he was actually giving Travis some instruction. He was in the truck with Travis, got up to Ahmaud Arbery, was in that immediate zone, had his gun out, didn't pull the trigger, which I think his lawyers did a good job of pointing that out, that if you were going to try to do a citizen's arrest, you should do it more like Greg did than Travis did, where you go up, you try to stop him, you maybe show the force without using it. You've used verbal commands, even if they're verbal threats. I also think some of the things he said, like stop, will blow your head off, something like that, and then it ended up, that's what happened, not blowing his head off, but they do end up shooting him. So all of that, I think, makes him a lot more culpable than Roddie, who was in the car behind, who was filming it. I think he did accidentally hit him with his truck, though, which is what brings in the felony murder. But again, I call me naive, I do believe kind of that Roddie was not as intentional about it. He didn't bring a weapon. He wasn't, all gung-ho like the McMichaels were, at least as the evidence came out. Roddie's lawyer also really testified for him in the closing arguments, which I thought was interesting. If I was the state, I would have been pounding the table. Like, dude, this guy didn't testify. You can't tell us what he was thinking, who he knew, where he was going. And that's how his lawyer kind of did the closing argument, which I thought was funny. But Roddie and other people that get convicted of felony murder. So from a non-criminal defense lawyer who understands the law and how statutes work, anytime a death happens, when you're involved in the commission of a felony, and usually people think of felonies as the more serious crimes, which is correct. But there are a lot of crimes that are felonies that are not as serious, especially when you think attempted assault.
Yes. Okay. So this came up a lot with the Chauvin trial, where he ended up getting felony murder because they say you're assaulting him when you're on his neck, and then you're killing him when you're on his neck. So now we're going to give you felony murder instead of manslaughter, and that I thought was a uniquely bizarre way of looking at the law in Minnesota. And apparently it's not. Apparently other states had this also. So the overall theory behind felony murder, I'm totally on board with. When the predicate felony is assault or attempted assault, to me that's insane, because anytime you kill anybody, and in almost any fashion, you're assaulting him one way or another. If you get in a bar fight and you throw a punch at someone and they fall backwards and they snap their neck over a bar stool and die, well, you were trying to commit a felony, and now accidentally, you weren't trying to kill the guy, but you're trying to commit the felony of punching him, and now he's dead. Felony murder instead of it being your typical manslaughter. How do you ever have manslaughter? Every manslaughter is a felony murder. So, it's very, very confusing to me when you're looking at felony murder, how there's any sort of legal rationale to coming up with a statement and saying that the underlying predicate felony will be aggravated assault. And this is something that I'm a very strong believer that it's a backward way of legal analysis. I don't know if you were able to hear me or not.
Yes, I heard the whole thing.
Okay.
People are telling me my mic is not sounding right, so I'm trying to plug in this mic, see if it works.
I wasn't sure if it was you or my headphones. Honestly, there's sort of like coming in
According
and out.
To the people, it's me. Let me see here.
All right, I win. Nice.
All right, let's see here. All right, so when we talked about whether or not it was surprising, you said you thought potentially the Malice murder was surprising. Is this though after hearing the evidence?
Yeah, so still, the Malice murder, to me, how do you come up saying that beyond a reasonable doubt that he had malice in his heart? Like, how bad must he have been on the stand that if they come to a conclusion that there's absolutely, it's beyond a reasonable doubt that he wanted to see Arbery dead? How does anyone reach such a conclusion? It's mystifying to me. And what seems more likely to me is it's along the lines of what you were describing. The jury basically felt as if, okay, all three of them are guilty here in varying degrees. And we sort of look at Gregory as being mid-level between the other two. So Gregory deserves felony murder across the board. And we'll make Travis more guilty. How do we make him more guilty? The only charge we have left is giving malice murder. And we'll make Roddie less guilty, and that's why we'll knock off one of the felony murders. It almost is like there was a grading system by the court, by the jury, as to who's guilty, who's the guiltiest of them all, and how do we rank them. And once we come up with this rankings, let's give them different level guilt charge or different number of guilt charges, even though at the end of the day they'll likely be facing very, very similar sentencing, if not identical sentencing. It's not like when you get 3 felony murders for killing one person, you serve 3 life sentences, you get the same life sentence. So just because the
big question I think is parole, and I don't know if my mic is any better.
I think it's clearer now. I think it's clearer now.
If not, I'll go get my headphones and
yeah, it's not better actually. I'm hearing the same static now.
Okay, so let me ask you this question when I go, just for the viewers, they can listen in on this, and I'll go grab my headphones. But so when we talk about, and one of the differences between the sentences is going to be whether or not they get parole.
Okay.
So that could be one of the bigger differences. But what are some of the takeaways from just watching the trial and listening to the lawyer's arguments?
So I actually thought that the defense counsel in this case was far stronger than what Kyle Rittenhouse had. It was actually a very stark contrast between them. I actually wanted to I was wondering if I could get your take on that also. What we saw in the Rittenhouse trial, even though, and it's ironic that I'm saying that, in a layperson, I think they probably, if they would hear me say that, they would think I'm out of my mind because of the success, the relative success and failure, and from the eyes of the defendants in each of those two cases. Obviously, Rittenhouse was cleared on all charges, and whereas you have the defendants in this case, where I'm saying the lawyers were better, they were found guilty on all charges, or if not most charges, and they're also facing life in prison. But as an attorney, our role or providing information to viewers about how a case is going, our role is to assess what seems like a healthy strategy to increase the likelihood of success for your clients. And similar to the way a coach in any sporting for any sports team, or manager of a baseball team, or a coach on a football team, you might not have the same talent as the other team. You might not have the same. You might not. The other team might be much stronger, but the goal is to set yourself up in the most likely to increase or maximize your likelihood of success. And that's all any lawyer can do in any situation. You're dealing with the facts and the law that's coming to you. Now you can try to pin on certain parts of the law. You portray the facts different ways. You have a million different decisions to make as to what type of evidence to proffer, how you're going to frame your narrative, how you're going to sculpt your arguments, what sort of evidence you're going to make a big deal about, when you're going to object, when you're going to stay silent, how you're going to phrase your questions. There's literally, there's no two lawyers which could ever possibly try a case identically. However, when you're looking at a lawyer, you can see, and the questions that are happening as their witnesses are called to the stand. And when I was watching the Rittenhouse trial with a half a dozen other lawyers, and again, I'm not a criminal defense attorney, but I still was able to watch them, and five of us are unanimously are just intuitively screaming at the exact same moment, object, object. And Mark Richards, for the Rittenhouse case, is sitting on his hands and just sitting there silently when there's just crazy evidence that's being admitted by the state. And when we're talking to each other, should he put him on the stand, should he not put him on the stand, as far as putting Kyle up and waiving his Fifth Amendment rights. And every one of us is like, why would you? I mean, the state did such a lousy case in presenting their case. You don't have to present defense. As soon as the state sits down, you just say, defense rests. We're done. Go, jury. Tell us if he's guilty. And that probably would have been strong enough. And there's a lot of bad evidence that came up later, which was introduced after the defense gave their set up their defense, which actually potentially put Kyle in a far more dangerous position of being convicted. So we talk about the provocation evidence that ended up coming in. So all of that, makes people, or made, many attorneys, and virtually every criminal defense attorney I know, question Richard's effectiveness as an attorney and say to themselves, look, his facts were way too good for even him to blow it. That's how a lot of people look at Richards. I don't know how you looked at it. I don't know how closely you were watching him on a day by day basis, but that there's so many things he could have done to present his case more strongly and protected Kyle. When Kyle's on the stand there, he's getting badgered with the same questions over and over again. And he's just letting him instead of sitting there like a father figure, protecting this kid from hearing the same questions 9 times. He's just sitting there and quietly. It looked like Kyle was looking over at him like, really? I gotta still answer the same question as to whether my gun was aimed at his feet or not? Like, you asked me this 6 times, and on the 7th time, okay, fine, my gun was aimed at his feet. It was just mind-boggling. And in comparison, because we're really focusing on Arbery here, I thought that from what I saw of defense counsel, I thought they had interesting styles. They had very different styles. We had Rob Rubin there, who, he's the one who looked a little bit like Henry Winkler, and his associate Jason, was it Jason Schaefer or something to that effect? Sheffield, something like that.
I'm not sure. I don't remember their names.
Yeah, but so they were. I thought that their approach in defending Travis, they just came across as if they were on top of how to understand what a jury is hearing. They seemed attuned to understanding this is what our audience needs to hear. and and as far as protecting their clients, as far as what to do with their situation, with respect to Travis McMichael, there I felt he probably has to take the stand. It's a very different scenario as to how the state is setting up their evidence and things of that nature. I thought even Kevin Guff, while he was a little bit quirky, and I was counsel for William Roddie Bryan.
Yeah.
I thought that his decision to hold back in giving his opening statement until after the state closed, I thought that was a brilliant move, because he's thinking to himself, you know what? Both of the co-defendants had their opening statements. My statement's not going to be that much different from them. So the jury's already heard our side of the story pretty much. Why don't I get a chance to get up and talk before I present our case in defense, after I've heard everything the state has presented? So I thought that was showed unique insight. I thought his strategy of making everything racial was a little bit bizarre. I'm not going to kid you, where he started calling out about black pastors in the jury and things of that nature. But I thought the counsel here actually was far stronger than what we saw in Rittenhouse. Can you give me one moment, because I got some my wife is here and she needs me for
Go ahead. I'm gonna kind of respond a little bit, and I'm bummed that my mic cut out and I had to step away for a second. I'm really sorry for everybody watching. I wish I could have heard everything he said about Kyle Rittenhouse's defense lawyers, so there may be some repetition, but I did want to talk about that. And I also wanted to kind of talk through how I would compare the defense attorneys' the style and skill, basically, when it comes to Rittenhouse versus Arbery. So what I just said was, I was bummed I missed what you said, part of what you said about Rittenhouse's lawyers, but I heard the end of it. So I do want to talk through that, and then also comparing it with the Arbery defense lawyers. Hopefully my mic's better. If it's not, I'm gonna have to do the best I can.
I think you're great.
Video.
I think you sound better than I've ever heard you in my life.
I appreciate that. All right. So I thought, and I've heard a lot of criticism for Rittenhouse's lawyers. And I talked about it a little bit on this channel, and some people thought I was taking shots. I'm not a guy that takes shots at anybody, especially at other people making YouTube videos. I thought it wasn't perfect, right? But I think if you've ever tried a very serious criminal defense case, it's very hard to be perfect. I think that the judge was helping them. And yes. I think that when the judge is good for you, which doesn't happen a lot when you're a criminal defense lawyer, you want to continue it down that line, right? You don't want to do anything that's going to make the judge kind of come down on you. So that's like the over objecting and the stuff like that. I agree with you. I thought the two worst parts by Richards were while Kyle was getting crossed and his closing argument. I thought his closing argument was kind of all over the place, here, there, everywhere. But I actually thought.
Really? That's interesting.
That's my opinion.
No, go on, please continue.
And I think his second chair was actually really effective, especially in the motions arguing and dealing with the jury instructions. I actually thought he was really effective, and I was hoping he was going to do closing once Richards did opening. But I thought they did a lot of things that I thought were skillful and keeping the pressure on when they felt like it was going well for them. One of the thoughts of that was opening. When Binger was making arguments like, well, I didn't use any of the video in opening. I didn't use any of the photos in opening. It's like, well, that's not the standard, man. Like, just because you didn't use it, we all agreed all this stuff's coming in evidence. I'm going to use a ton of it. And he did. And I thought he did a good job in opening and kind of setting the case. And I thought, again, Binger calling these witnesses that were bad for Binger. And I thought the defense did a good job of getting up and making it seem like it's a defense witness. I thought Greg McMichael's lawyers were actually pretty effective. I actually liked her closing argument. I thought she was pretty effective throughout the case. I think Travis's lawyers
were grading on the judge. They were grading on the judge.
Yes. And I thought waiving that, even if you can't prove that first part of the citizen's arrest, waiving that in your opening and agreeing to that and kind of stipulating to that without knowing what the jury instruction was going to be.
Oh, yeah, I
am like floored at that. Like, to me, I don't ever want to say anything's malpractice, but that is, you can't do that in a trial. You cannot waive anything. We don't agree to waive anything unless, and we already talk about these jury instructions before the trial happens. So if you didn't agree to this jury instruction ahead of time, then you just leave it open at this point until it's solidified, until you have what the jury instruction is going to be. So I did not think Travis's lawyers were effective, and I had a hard time because now the jury didn't hear all the stuff that Roddie's lawyer was saying outside of their presence, but I had a hard time thinking he was effective just listening to all that mumbo jumbo he was trying to do, which I don't think was helpful at all to his client in the courtroom, to the jury, to the media, to anybody. I did not think that was very helpful. What did you think about the judge in the Arbery case saying he thinks there was racial discrimination in the jury selection process?
I actually liked him a lot. He seems like someone who runs a bit of a tight ship. I liked him far better than I liked Schroeder. I thought that Schroeder was far too loose in what he allowed the state to get away with. And he seemed like someone who's determined to actually try everything he could to keep things fair on both sides. Even when the way that he undressed that co-counsel for Travis McMichael there when he got upset with him, but the way that he did it and sending the jury out and everything there, that's why I thought that Sheffield was a little bit crazy with how he sort of he showed like a flippant disregard for what the judge thought or cared about. And that, yes, that was definitely poor. It's not just, you don't just look like a poor sport, and the jury's not seeing him do that, but still you have nothing to gain by taking off the judge, literally nothing, and a lot potentially to lose if you took the judge off. So yes, that was definitely poor. To be fair, I spent a lot more time watching Richards in action. Well, I guess in action and inaction both.
Right.
And
in action.
Yes. Then to watch different defense counsels. I got more of a synopsis as to what was happening with defense counsel. I did think that was an interesting thing for the judge to call him out on. And it's something that, I mean, let's be fair here. Let's be reasonable. This is a racial case. Far more than the Rittenhouse case. This was always going to be, was a trial about, are these three racists out to kill a black guy? That's just how the whole thing, it has to be, because of the skin color of the victim, which you didn't have in Rittenhouse. That's going to be playing out here. Now, with that in mind, we are not ethically allowed to choose a jury based on their racial composition. You're not, everyone is told that. Anyone who's ever litigated anything knows that you're not supposed to, ding someone off and use one of your peremptory challenges and get rid of them because you don't like their particular skin hue. And yet at the same time, you almost feel like to disregard that is malpractice, because you have to deal with the reality of the world. Now, it's not malpractice, obviously, because we're required to act a certain way. But the judge basically noticed that they had whittled down the jury pool to 48 potential jurors, of which 12 were black, and virtually all of them were just, one after another were knocked off by defense counsel. I think each of them had like 6 peremptories, and between them, they pretty much effectively knocked off all but one, or I'm not sure if one made it through or not.
Yeah, one ended up.
Through. Yeah. So, and I mean, I wasn't surprised that happened. Let's put it that way. I was not surprised that happened. It's unusual for a judge to actually call attention to it. That's a very unusual thing to happen.
Especially the way that he did. And I know, like, it's frustrating when you pick a jury, and I talk on my channel all the time for people that roll their eyes at jury duty. I just spoke to a local high school about, turning 18 and how the law changes for you when you turn 18. And we talked about jury service, and they raised their hand, and some cool kid in the back was like, yeah, I got called jury service. And I was like, okay, how'd it go? Did you get picked? He goes, I didn't show up. It's like, okay, cool. You're hilarious. You're awesome. Then when you get arrested and nobody that looks or acts like you shows up, you're going to be frustrated. And that's the problem. Is I tell everybody on here, like, if you want to see that change in the system and you want to see an actual jury of your peers and representative of the community, then everybody's got to show up from the community for jury selection. Answer honestly. If you're not a good juror for this case, fine. But that's always the problem. It's so hard to find a diverse jury, not just with race, but with everything, with age, gender, race, socioeconomic status, everything. It's really hard to not just get a jury of 6 or 12 retired people that are fine being there and they're not trying to get out of it. And I think that's a tough thing to tell when you're looking at and picking a jury.
Yeah. It's funny you say that. I actually recall you're too young to remember when Rudy Giuliani was mayor of New York City. So they had
Mhm.
actually recently passed a law saying that attorneys could sit in a jury, which had not been the law in New York prior there too. It was like a year or two before they passed that, and he was served with jury duty notice, and he showed up and he ended up sitting on a trial. And I was thinking to myself, would I want him sitting in the jury? I guess it depends, because his decision is gonna. You're basically just he's practically just like the judge, because you practically have a bench trial. Where it's my goal is to convince Rudy Giuliani. If I convince Giuliani, everyone else is going along with whatever he's deciding. So it's like you end up reducing down to a jury of one for all intents and purposes, because you think someone else is going to convince Giuliani you're wrong on the law on this case? No one's really. Is that really going to happen? Okay, when he's sitting mayor and a former district attorney for the city, like that's going to happen? I don't think so.
No, I agree with you. And usually one of the fun things is trying to pick out who the foreperson's going to be on the jury. I have had a jury or a lawyer on my jury one time, and it was a 4-week federal criminal case, and he was so mad that he got put on it. But he was a pre-lit civil lawyer. He didn't do criminal law. He never did criminal law before. So he didn't have like the automatic biases. And we kind of wanted somebody that was going to understand how the process worked, because it was an entrapment defense that we were putting on. So we wanted him to be able to understand it maybe. And he ended up getting off week 2 because something happened at his office. So he was, forced to leave the jury, which was interesting. But that's what happens with jury duty sometimes. And we had, a lot of alternates. But in this case, the racial element, I think, was part of the case no matter what. And I think that it didn't end up going well for the defense. I think it could have gone better for them if they would not have been so, I don't know what the word is, but it's almost like they played into it, more than the prosecution did. I actually thought the Rittenhouse case did a good job of kind of keeping it down the middle, and they didn't really talk a ton about it. Like I didn't think it felt like a racial element. Did you? I didn't watch every second
No,
of it. I watched as much
Rittenhouse
as
was
I could.
Rittenhouse is very much not a racial trial. It was that did not come up at all. The state there was so much abusive process there. Like you said, you didn't get to watch much of Rittenhouse.
I
So
watched a bunch of it, but not every second. No, I watched a
but
lot of it, but not
no,
every. I
okay.
actually had a federal trial the week Rittenhouse's verdict came in,
Oh
I
wow.
actually watched more of Rittenhouse than Arbery,
Arbery.
because
Yeah.
Arbery I was actually in a trial myself.
Well, the so wait, let me think about
We're
your.
talking about the racial elements in
Oh
Rittenhouse's
yeah,
trial.
so that never came up at all. That never came up. That was, in fact, the
You,
state was so flustered at watching their witnesses collapse one after another. I mean, everyone who got up there, as you said, they ended up sounding like they're a witness for the defense. It was a joke. I mean, okay, let's look at this. They put Balch up there, the former Navy SEAL, and he gets up there and testifies that Rosenbaum threatened him and Kyle that if he ever got them alone, that he was going to kill them. That's a state witness. They want to put up someone who's going to say that Kyle was threatened an hour and a half before he shot Rosenbaum by
and then they called him
Rosenbaum.
a liar later.
Yeah, and half their witnesses, they end up basically cross-examining their own witnesses, because we're like, we don't like this thing you just said. We put you on the stand, but we don't like what you said, so now we're going to cross-examine you and make you sound like the biggest liar in the world. Well, why are you putting this guy on the stand if you think he's really a liar? I mean, that's pathetic. They put Richard McGinnis up there as the victim of criminally reckless endangerment by Kyle, because he was behind Rosenbaum at the moment of shooting. And McGinnis basically is like, yeah, I mean, I moved out of the way because I thought I might be in the line of fire. But he's describing this scene where he said that Rosenbaum lunges for the gun, and Binger, the ADA, is basically saying, well, you said on Tucker Carlson that he fell and that Kyle shot him while he was falling, as if he shot him in the back and stood over, he's painting an image there, like he stood over his body, like laughing, ha, 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 while he shot him, shot him in the heart, and it went straight down. All the forensics show it was coming in at an angle that he's moving forward. He's not down on the ground. But then Richard McGinnis is getting up there and he's like, no, I said lunge. I meant lunge. You're falling forward as you lunge. And he's clarifying it, and it's killing Binger. And then when he's saying how Rosenbaum was grabbing for the gun, and there's a classic moment of the case where he says to him, well, you don't know what's in his heart. You don't know what he was Rosenbaum. You don't know that he's really reaching for the gun. So, and the classic response, he looks at him, he's like, okay. He said, he screamed F you and lunged at him. So it's like that, you win. You win. He wasn't like, it's almost like he wasn't lunging for the gun. Like, what are you can deal with common sense here. I'm not inside his brain, but there's enough there. I knew exactly what the hell he was doing. So, and then you see the worst was Gage Grosskreutz. That guy looked like he was straight out of like Bad Acting 101, where he's like, every time he's answering, he's like looking at the DA and turns to the jury and says like, that's, I thought I was going to die. And then looking back at the DA, it looks so pathetic. And he's describing how this is what Gage Grosskreutz did. And Sheriff as you pointed out correctly, Sheriff just toyed with him and just brought him, just punched and ended up making Gage like the best witness he could have that Kyle ever could have dreamed of having. He ends up getting him to admit that he's chasing after Kyle along with the mob because he's afraid that Huber is going to kill Kyle. Like, the one thing is, how do you get him to admit basically that the mob is going to kill him? Why did you he's like, well, I'm a paramedic. I was hoping I could save him. And and here's a picture of you reaching for your gun while you're running after Kyle. Why are you reaching for your gun? He's like, well, I thought I wanted to help him. I wanted to help save him. He's trying to play himself as the white knight. And then he's like, you can't even see Kyle in this photo. Must be at least 20, 30 yards ahead of you. Is that how far ahead? Yeah, he's 20, 30 yards ahead. I'm grabbing a gun there as all these people are running after him and chasing him. I wasn't chasing him. I was just running with those other people to protect him. And it's like everything he was saying, and then he's describing how Kyle got hit in the head, and this guy's hitting him. Everything he's saying there is setting up perfect self-defense for Kyle. And then finally you get to the denouement there, and you have the moment of truth where there's this face-off between Kyle and Gage, and he said he gets him to say, so Kyle never shot you until you aimed at your gun at his head. Is that correct? And he says, yeah, that's correct. Boom, game over. That's like directed verdict. And because how do you not call valid self-defense, at least with respect to that charge? Someone aims a gun at you, you have every right to shoot.
Right.
So I want to ask you, as a criminal defense attorney, okay? First of all, have you ever handled a capital murder defense or no?
No, never capital murder. We've had multiple life murder cases.
Okay,
and
so fine. That's good
murder
enough.
cases.
That's good enough.
Yeah,
that's good enough. Yeah, it doesn't.
Never a death penalty case. Me personally.
Right. Well, he was never in threat of capital murder anyway, so I shouldn't have said capital murder. So you represented a defendant who's charged with murder.
Yeah.
Would you, and if you were sitting as Kyle's defense, would you have thought of doing like right when the state rested, saying defense rests, we're done, and not going any further?
So we've done that in cases before, and we've even waived closing arguments in cases before as to not let. We've had an insanity defense on a murder case where the state focused all on the murder and not at all on the medicine in their first close, and they were going to come back in second close and rebut the psychologist and all of the people talking about whether or not he was temporarily insane at the time. So we waived closing. We've done it in two cases, actually. One of them, we got a not guilty verdict. We're successful. The other was a guilty verdict and we lost. So it's not like a foolproof plan. I don't know. I do think it went really well for them. I actually thought their expert did a pretty good job on explaining how quick everything was, because that was big to me. So some people in the chat are asking us to get back to Ahmaud Arbery. So we'll wrap the Rittenhouse stuff. Maybe we'll do another one. We can just kind of recap everything that happened there. But one of the things to bring it back to Ahmaud Arbery, two questions here that I want to talk about. The first is, what did you think of the prosecutor? There was a lot of talk about Binger through the Rittenhouse case. What did you think about the prosecutor in the Arbery case?
So again, the amount I was able to actually watch her in action was more limited, but I thought that she, from what I saw of her, she seemed more like your classic state prosecutor, what you expect from them. I thought she seemed smart and tough, kind of like your classic government attorney, rather than like your there is a different feel when you're talking about a government attorney versus defense counsel. Defense counsel, you sort of picture them being a little bit more like Binger was, like, like the um the well-dressed, I'm in charge of this room. I'm going to take over the room and you're going to feel my presence when I'm here. And this trial almost becomes about the defense attorney to some degree. And that's intentional frequently, because they want to sort of take the focus off of where the state's coming from. And I think that state attorneys are more about like getting out about the facts and just figuring out what their narrative is, figure out what's my closing and how am I going to get to my closing based on what I have here. And that's a healthy way to approach. It's a healthy by the book type of thing. And I thought, overall, from what I saw, she seemed highly competent, and I have no knocks on her. So
yeah, I thought she did a good job. I mean, I
Yeah.
think one of the complicated parts of the case was all these different charges, all these different defendants. And that can cut both ways as a prosecutor. So yeah, I worked at the prosecutor's office too at the beginning of my career. And when you have all of this, if it's a complicated case and not a good case, it usually goes bad when you've got 3 defendants in all these charges. But if you've got a really good case and a really bad set of facts, bad meaning good for the prosecutor, bad for the defendants, sometimes you basically can wrap them in a web or a net, and it's just like a coattail effect where they all get hit with guilty when you prove up this bad set of circumstances and you have them all together there, as opposed to, I've heard a lot of people talking about how Roddie should have severed himself from the case, which I absolutely would have moved to do that. I don't know.
So that's what I was going to ask you. That was you were setting up that question. Why would you have moved to sever it? Why do you think that would have been more effective here, rather than joining in? Do you think they were an anchor in pulling him down, or how? What's the basis to do that?
A, I think they were an anchor pulling him down. B, I think there was no way that a jury was going to look at these 3 guys, all from the same neighborhood, all kind of looking the same, that they weren't going to see them as separate individuals. I think they saw them as a group of vigilantes together, even though Roddie's lawyer tried really hard in closing to say he is not one of those. He's not the same as those. And if it were me and I represent Roddie, I would have gone to the law enforcement officers, gone to the state attorney and say, what can I do to help? Let me testify that they should not have done that. Here's my perspective. We drive up, I film him. I was going to give this video to the cops so that they could arrest him if he had committed a crime in our neighborhood again, like I thought he did. I accidentally hit him with my car. So if you want to give me some assault charge that I can plead to and do probation and I'll testify for you against them, that's probably what I would have recommended he do. So we don't know what their relationship was like up until the trial, but in the trial, he started backing away from them and not wanting to sit so close to them anymore. I don't know what it was beforehand. I don't know if they were boys before or just, I don't know. I know some of my neighbors, not all of them. I'm definitely not chasing anybody down with any of my neighbors. But so I would have absolutely severed it, because I think the trial goes way different if the state can only use evidence against him and they can talk about what he did, which was film it, drive after somebody he thought committed a crime in his neighborhood, accidentally hit him with the car. That's the hard part. I mean, listen, the jury's going to have to determine whether it was accident or purposeful, because a car can be a weapon, a deadly weapon. And you play the case like that. This is the guy that talked to law enforcement without a lawyer, gave the video, filmed the event, did not have a gun, did not grab a gun, did not point a gun, did not get out of his car, was trying to do the more appropriate citizen's arrest. Because to me, if somebody says, I drove my car after someone I thought burglarized my neighborhood, I am way more understanding of that than cut them off, got out of my car, pointed a gun at them, shot them.
Right.
That's my thought as far as severing.
No, and it makes a lot of sense. I was surprised that he did not sever, because you sort of, I mean, let's think about the pros of keeping a joint. Because look, obviously Kevin Guff must have gone through this calculus in his mind as to whether or not he should sever or not. I don't know if you're familiar with the process in Georgia per se, but I assume there's a motion you have to bring in order to sever it. And
yes.
And what cause do you need to show in order to convince a court to allow you to sever it?
So
The
there are
prejudice?
different causes in different states, but most of them center around public policy, just that it would be too prejudicial for him to be in the trial with them, which I think he could have done. And his lawyer did move to sever the case after the close of evidence when everything was over. And the judge is like, okay, I think this is untimely, and it was totally untimely. You can't wait until then because now the state's already used their resources. You've waived it at that point. But yeah, you have to file a motion, you have a hearing on it. And I think they could have presented evidence to say, even, and I know some people are putting in the chat like they tried to make a plea deal, whatever. I don't know. We all don't know what happens when these defend. I know the mom of Ahmaud Arbery was saying that she's glad the state didn't take a plea deal, but that was during trial. I'm talking early on. I would have gone and talked plea deal, and I think they would have taken it. I think they would have worked with Roddie, even if he goes to prison for a year or 6 months or something and gets an assault charge that he just takes a conviction on, testifies against him, and gets out of all this felony murder talk that he's in now. But yeah, you got to do it earlier on. You can't do it after they close the case. But I'm sure he did the calculus. What are the pros? What pros do you think come from not severing?
I'm trying to think that through because he obviously had enough pros that he didn't bring that motion before the trial started. So I guess the pros are, I mean, let's think about it like this. If it's severed and the trial of the father's son is held before yours, well, in that case, you know that if they walk, you're definitely going to walk, right? It's almost like as a matter of law, you have to walk. If they get convicted, well, in that case, you're seeing, you know, the basis of how harsh they are in conviction. I'm just trying to think like what the possible. I'm trying to think about there must have been benefits. So I don't think Kevin Guff, counsel for Roddie Bryan, is a moron. So even though he did some unusual tactics in this, I don't think he's an idiot. So I have to think to myself,
the pro would be, the only pro I can think of is you thought you're going to win on self-defense or citizen's arrest. And you thought if you all had a united front and nobody testified against anybody else, that's the pro, right? If he goes with them, then nobody's going to take the stand and say, no, actually, we had a meeting. Roddie was the one that said, next time we see this kid, we're going to get him, because that's a pro. We don't
is that
know
actually what happened? Was Roddie the one who said next time we're going to go out?
No. I'm not saying that. I'm saying that could be a pro if Roddie knows that, and if Travis takes a stand and is like, actually, Roddie was the one that set the whole thing up. But if you go together as a united front and it's almost like a joint defense agreement, then nobody's going to say Roddie did anything, and they can play him like the ho-hum, simple-minded guy that they tried to play him as. I don't know that to be the case. I'm just saying I'm trying to think of reasons why you wouldn't sever a case like this.
I mean, the United Front, I guess, is a benefit to the whole thing here. I'm just saying, if he's my counsel, I mean, I definitely like your strategy. But let's assume that didn't work. Let's assume that she said, no, I'm not taking a plea deal for him. He's going down with the rest of them. So if you have a united front, and I guess they're thinking maybe no one's going to testify. Maybe he must have. Maybe he thought that no one's going to testify. That the state's not going to have enough evidence here. Look, there's no witnesses. All you have is a very shaky video thing. They had to know the police statements were going to come in. And I think the police statements were probably very damning because of a lack of exonerating statements that are made there. There were a couple of somewhat exonerating things where I saw one part of the testimony. Travis McMichael was asked, "Are you okay?" And he didn't interpret that. The question was asked by the officer to try and elicit whether or not he was actually shot or injured by Arbery during the scuffle. And he took it as like an emotional type of thing. He's like, "No, I'm not okay. I just killed someone." And that's where his mindset was, that he was rattled by it. And I thought that helped portray him in a healthier light. I guess maybe Kevin thought that he's not going to testify, and that if he's not testifying, we have this united front. Hopefully there's not enough here for the state. If I'm here, and perhaps that we don't know what happened in talks between different defense counsel. It could be that there was a threat by the McMichaels that if you try and sever from us rather than staying as united front, well, you sort of almost have that prisoner's dilemma, right? You're familiar with the phrase the prisoner's dilemma, where they basically say, okay, if neither of you speak, you put prisoners in a separate room, right? Have you ever heard the prisoner's dilemma?
No.
So I think the prisoner's dilemma is basically like, if neither of you speak, take two inmates, two accused defendants who you know committed a crime in separate rooms, and you say, if neither of you speak, in that case, you'll both get 3 years.
Oh, yeah.
If one of you speaks, the one who speaks gets only 1 year, and the one who's silent gets 7 years. So the question is, now you're sitting there and you're saying, do I want to speak or not? Do I trust the other guy that he's going to remain silent? And it's possible that whoever would have come in first, that the state would have brought first the trial first. It's sort of like a dilemma, like, if I'm going second, are they going to testify against me? Are they going to turn on me? Are they going to make like this was all my fault? And if I'm there at trial, and I know that if I'm sitting with them in the courtroom, that if they tried turning on me and saying this was all my fault, they know I'm just going to point back at him and we're all going to get screwed here. So maybe that's sort of that I'm sort of securing that united front and stopping the McMichaels from pointing the finger at my client, Roddie Bryan, by sitting with them. Because for all they know, the McMichaels might be worried that well, I don't care what the McMichaels are worried about because I'm representing Bryan. But yeah, I guess perhaps it helps keep the McMichaels from ever trying to turn on Bryan.
I just don't see how.
It's very
strange. See how they turn on him.
I don't like it.
If you're the guy that pulled the trigger and you turn on an accomplice, what does that make you? He's not an accomplice to murder unless you're a murderer. So yeah. I don't see how Travis really turns on Roddie personally. That's what I'm saying. If I was Roddie, I would have been so far removed from these guys.
It's so bizarre. It's so bizarre what he was doing. I would love to hear his explanation of it. I don't know if we'll ever hear it. It's the sort of thing that he might end up one day, writing a book or long after he's retired, or he might remain silent until his dying day. But I am really, really curious why he did not sever here, because the United Front just doesn't seem anything worth. You're almost getting 2 shots at the apple if you sever. It's really, that's the benefit. You're getting 2 shots at the apple. If they walk, my client's definitely free. And if they get convicted, my client's still, he's not facing the same jury that convicted the first group. So if they're convicted the first group, they're angry and they're riled up. Now I come in here, I say, yeah, they did what they did. They did what they did, but I wasn't a part of it. And I was recording it because I was worried they were going to do something to Ahmaud Arbery. Right? He could have come up with that. He said, I wasn't part of the chase. I was following those bad guys who were chasing Ahmaud Arbery. He could have come up with that.
Yeah. Yeah. And I don't know if the interviews with law enforcement officer already connected them all together and they were inextricably intertwined, so he couldn't sever, but
yeah, I guess. But even if they're intertwined, maybe he wouldn't be able to make that claim because of what the police statements that he made. Still, yeah. You don't need to be tried with them if you can, you can.
I agree.
At least try to show prejudice. Yeah, I can't answer it.
So I think that's appellate issue number 1 potentially for Roddie. Were there any other glaring?
How's that appellate issue? What's he appealing on?
If and I don't know because I didn't look at the docket. And people like trash me sometimes in the comments because I don't read all the transcripts and read every motion that's filed in the case.
I'm about to trash you too, but so walk carefully here, brother.
Exactly. It's okay. I can take it. So I didn't read all the motions. I don't know if he filed a motion to sever, but let's say he filed a motion to sever. It was denied by the judge. He renewed that motion in the trial. That could be an appellate issue. If he says the judge should have severed the case and didn't, if I'm Roddie's lawyer, that's appellate issue number 1, in my opinion, if he protected it. But were there anything else that stuck out in the Arbery trial that you felt like, wow, that's going to be a major appellate issue? Majorly unfair, or you just thought you couldn't believe that came in? Potentially the jury instruction.
Oh, so with respect to the jury instructions, so it was weird that as far as the whole reading of the case law, that was what they were. Yeah, I had heard that the way that he read the jury instructions here were a little bit unusual, and that might create an opening on appeal. But I'm still wrapping my brain around that first one with respect to the whole severance. If he the denial of right to of an ability to sever it after the state closes, I can't imagine that something's going to be successful in appeal. I mean, I was trying to think if you were going to go down the road of saying a failure to move to sever it, since you and I, 2 fairly intelligent individuals, cannot think of very good reason here not to sever it. So you might try and argue ineffective assistance of counsel in that he didn't work harder to try and get this thing severed long before long before the case, the trial, went to jury. But those claims never work on appeal. When you say ineffective assistance of counsel,
They very rarely work.
the standard is so bad. He could have been sitting there with his head down,
it's so
snoring
sad.
loudly,
I know.
snoring loudly, and they'd be like, "No, that's good counsel right there."
It is really sad. We've had cases where clients have hired us to do appeals. We've actually been really successful in criminal appeals, but we only take certain ones, so it's not really a fair estimate. But we lost one where the entire case, the defense attorney did not object once. And it's like, you don't object one time to anything the prosecutor does, says, questions asked, nothing, and that's not ineffective assistance of counsel. So that was really sad. So the bar is low. But I think Travis McMichael is going to have a legitimate argument that the fact that the false imprisonment, citizen's arrest jury instruction, the way it was read and the way it was argued and waived basically in opening, I think he's going to have an argument that was ineffective assistance of counsel. I don't know if it's going to be enough to rise to the level like we're talking about.
Please, that never works. That never works.
Everybody does it.
Yeah, everyone literally claims my lawyer sucked. That's like the first thing when you go to your appellate attorney. That's the first thing he's already got that pre-written in a boilerplate. He just fills in the details about yours. But yeah, and the appellate court knows it, so, and that's why they yawn when they see it. You gotta have something really leaping out of the page, and if your attorney stands up and says he's guilty and starts screaming that, okay, fine, but short of that, ineffective assistance of counsel,
it's pretty bad. I mean, the only things that like really criminal cases get appealed on is FBI destroyed evidence before the fact, or they didn't tell. There was some Brady rule violation here in Florida where it's exculpatory evidence.
In Kyle's case, look, I know your audience doesn't want to hear about Kyle. In Kyle's case, there's probably 4 different reasons why he would have won an appeal if he was convicted, or had really great basis for an appeal. But I don't see. I haven't heard of anything. And again, I didn't follow nearly as closely as the Rittenhouse case, but I've spoken to a bunch of attorneys about how this case was progressing. I've been watching different things on it. I haven't heard anything that unusual, which made me think to myself, oh, wow, I guess they're going to back pocket that if they get convicted. I don't remember feeling very many moments like that. So
yeah, I
the only thing I guess you could say, I would tell you this. I think that Travis McMichael has a fairly decent appeal with respect to that one count of the malice murder, because I don't know how any jury could. It's almost like they should have gotten a directed verdict with respect to that count, because if the state hasn't put on any evidence at all to establish that they went out there with an intent to murder. So on what basis would any jury reach such a conclusion? It's beyond, that's practically a jury nullification.
So I'd have to read how that is worded, because I don't know if it's intentional murder or just murder with malice aforethought, or malice murder, depraved heart murder. I think that could be the.
I read it earlier today. There was a guy I actually looked up, and I found it pretty quick. I can actually share it with you here if you want to share with your audience.
Yeah, that'd be great.
Looking at before. Give me a second here.
Yeah, go ahead. While you're doing that, I'll just kind of talk through. The prosecutor, I thought, in the Arbery case did a really good job of making a complex way that they prosecuted this, with all of the charges like we talked about, and of having all 3 defendants. She went through every single one of these charges, all the felony murders, all the assaults, attempted assault with a deadly weapon, explained why there were all these different counts. I actually thought she did a good job and made it seem fairly normal as to why they were charging all this, because as a lawyer, I'm like, whew, there are a lot of different charges, a lot of different ways of saying the same thing. It almost seems like you're piling on and throwing everything against the wall to see what sticks. But I actually thought she made it make sense why they did what they did.
Not just an effective by the book attorney. And that's really what you want from that's what everyone should want from from a DA. I share with you a link in the private chat, by the way, for the malice murder. So if you click on that, you'll see what I was looking at, where they cite the Georgia code in defining what qualifies something as malice murder. I lost you. Oh, no. So, welcome to Good Logic. I'm your host, Joe Nierman. I stream nightly from from 10 p.m. Eastern until midnight. So I think what happened is I shared the link with him, and he's obviously never had a guest share a link with him before. So he wasn't accustomed to that. But it's supposed to just pop open, and then you have to share your screen down here on the bottom of StreamYard. But I'm sure he's gonna be right back. So nobody freak out or anything. Yeah, there you go. You
Here
see,
I
I
am.
was
Thanks for
predicting your
holding it
return.
down.
You have
Yeah.
to share. You have to click on it. It opens up a new browser. Then you share screen, and then you share, and you share that directly with
Okay.
everyone.
So yeah,
So
I looked at it. I saw it. So yeah, it just has to show intentional or implied malice. So it doesn't have to be intent to murder prior to the murder necessarily.
so how do you show that there was malice? Like, what basis is there malice that he pulled out a gun on the guy? I mean, then every case would be malice murder. How do you establish How did the state sufficiently establish malice that a jury can reasonably conclude that beyond a doubt he had malice when he pulled the trigger?
I agree with you. I think that's a hard thing to prove without, before he took the stand, basically. And I also think that you're right. The reason the verbiage is used the way it's used, it's like, who does not have malice in their heart when they're pulling a trigger and somebody's standing in front of them, right? So it's kind of like they're using it as just
And the video itself shows him struggling for the gun. If he let's put it this way: if they really went out there with an objective of killing Arbery doesn't get close enough to grab the gun. If that was really their intention, to go out there to kill that black kid because they don't like him for whatever reason, whether it's his skin color or something else, but they had genuine malice of, we want this kid gone, and no questions asked, he doesn't get close enough to grab the gun. They shoot him when he's 8 feet away, 10 feet away.
I think that they can have malice, and potentially did, and we're chasing after him with malice, not necessarily the intent to kill. That's I think that argument.
Oh, so you're doing transferred intent. You're saying transferred intent to their intent to catch him towards the actual moment of death.
Right. Like there was malice there, and the malice is what caused them to pull the gun, get out of the car, and then boom, the murder happens.
But the statute says that it's got to be on a person commits the offense of murder when he unlawfully and with malice of forethought, either express or implied, causes the death of another human being. So it's not that it's not their malice of intention to catch him. That's why you have felony murder. But I don't know. I mean, the whole basis of felony murder, and you saying how you hate felony murder, but I don't know if your hate is reserved for just when the underlying predicate is assault, or whether it's all forms of felony murder that you object to. But I think that when you're taking transferred intent, part of the underlying legal rationale, and the law is supposed to be logical. It's supposed to be something that we all understand, not just arbitrarily written. So if you're part of the thought in a felony murder is that they have the intent to commit that felony, and that is what is, we're sort of transferring that intent to that moment of manslaughter and saying that, so that's what felony murder is. Now you're basically saying it's also malice murder, that when they intended to do this false imprisonment, when they intended to hit him with a car, when they intended to trap him, all of that we're going to transfer to the moment of death. To me, that's what felony murder is. And felony murder is clearly something different from malice murder. So that's why I do think that Travis McMichael probably does have, a moment, enough of an appeal on that particular murder charge to give the appellate court pause before they just say, "Nah, we're denying this." At the same time, I want to ask you, if you're his defense counsel, if he comes to you, let's imagine he literally contacts you, Travis McMichael contacts you and says, "Hey, I want you to appeal this malice murder." Would you take his money, or would you say to him, "Look, even if we win, you still got 4 more felony murder charges. Like that's what are you gaining at? You're going to spend $50,000 on this appeal and waste and invest that money. And if we win, which I'm never going to promise you that we will, but if we win, okay, you're still convicted on 4 felony murder charges." So my question is, does anyone actually hire attorneys to do that?
Usually they would not just try to appeal one conviction, especially when he's going to get multiple life sentences potentially. So that wouldn't make any sense to do that exactly for the reasons that you described. I still think that, so I think the malice can cause the murder, and I don't know if I'd call it transferred intent or more continued intent, but the the reason I don't like felony murder is those felonies have consequences. They have elements. And when somebody dies, to put a murder charge on Roddie, to me, seems like too much, right? Like if he would have gotten an ag assault charge, okay. That's my issue with it is, and I think it's a workaround in cases. And I think it's too easy for prosecutors to just, everybody's getting murder, especially I think it's used, it very rarely happens in real life situations like this. Like if there is an accidental death when a felony is being committed, we can usually almost always keep out felony murder. Now, sometimes it comes in, but when a case is politicized or the media gets in, felony murder.
It's interesting. It's really interesting. And I'm thinking about what you're saying here. Because to me, I would, if I had to, I don't know. This is a gut feeling. And usually when I have a gut feeling, this is what I find about my own gut feelings. And I don't know if you may be the same, you may be completely different on this. My own gut feelings about things that are legal are when I have a gut feeling that something is a certain way, it means because somewhere in my brain, there's sort of like, there is a legal rationale that ticks off to it. And I'll come to that later. And maybe it'll even happen during the course of this conversation. To me, my gut feeling is appropriate felony murder is if someone is consciously engaging in a felony for personal gain. And because that is, I'm picturing like your classic burglary or even a drug deal or something like that, where it's like the person, and I think part of and my intuition, I guess, is leaning this way because I'm thinking like in those scenarios, you're in a bank robbery, everyone, you know that you're creating a dangerous situation. You know and you also are well aware that that you're engaged in a felony. You know that what you're doing is clearly criminal conduct. In a situation like this, I don't think any of these three people knew that what they were doing was criminal. They don't know. They think that they're doing a lawful citizen's arrest. Ignorance of the law is not a valid defense, but to their mindset, what they're doing is protecting their community and that they are in the right. And the next thing they know, the guy's dead and they're facing life in prison because of this felony murder. This is not something that's personal gain where they're knowingly going out to commit a crime, which is what in my mind, in my heart, how I always felt that felony murder would be appropriate. So in a bank robbery, yeah, if I'm a lookout and I'm helping, and I know that my people I'm going to be splitting up the money with are inside there training guns on people and getting them and getting the money. I'm the lookout, I'm the getaway driver, whatever it is, and then something goes wrong and someone gets killed. I can understand attaching felony murder to me because I'm enabling that entire felony, and I'm well aware that someone might die as a result of my attempt to get personal gain. But when you have someone
So this is the difference, I think, between Roddie and the McMichaels. I think when you grab your shotgun and you chase after somebody and you're holding your shotgun when you get out, you know that's a dangerous activity. Whether or not you thought it fell under citizen's arrest or whatever, you know that's a dangerous activity. Roddie not necessarily knowing that they have guns, that it's a dangerous activity. And that's not your explanation of what you think of in your gut of felony murder. I can understand that as a policy argument. Unfortunately, it includes me being unarmed, breaking into a house to steal something, and somebody having a heart attack because I broke into the house and they die. Felony murder. There are all sorts of situations where it's not necessarily dangerous, you're not really intending to hurt anybody, but you commit. And again, I'm not one of these, you just let him go, it's no big deal, he needed to steal for his family. Not at all. You get convicted of burglary, you go to prison, you pay the price for the crime you committed. But I think the tack on murder to that is too much, is too heavy-handed.
Well, personally. I would say, okay, I would say, okay, fine. But now as a result of that, this guy's family just had to bury him. So
I agree.
So that's why I understand. I guess you could say maybe keep it at manslaughter. Give him burglary plus the manslaughter. You don't have to raise it up to felony murder in order to get punishment for it. Which I can understand that argument. We're talking policy.
I just think it's interesting.
We're talking what's appropriate legal policy. and these conversations are very interesting to me because you're sort of assessing as what seems just, what seems not what the law, but what is just, and what is just justice. So
Mm-hmm.
yeah, that's I actually engage in conversations like this in my live stream a lot. Like
Yeah.
I have a section dedicated toward humanities where I'll try to just analyze. I cover a lot of politics also outside of law, so I'll try to cover like what's the difference between a right, what makes something qualify as a fundamental right as opposed to just a right. What
Right.
in your mind, and try and just sort of flesh these things out. To me, I enjoy engaging in conversation like that.
So a couple
Yeah.
people are asking real quick. So maybe we have 5 or 10 minutes left.
Okay.
They're asking us talk about the verdict. What's the verdict? So we've talked through the verdict a lot. They were all found guilty on at least one felony murder charge, which is going to carry with it a life sentence. Judge will determine, I believe, whether or not parole will be in their future. Travis McMichael was guilty across the board, including malice murder. Greg McMichael was basically guilty of everything but malice murder. And Roddie was guilty of multiple felony murders, ag assault, false imprisonment, etc. So, this verdict coming down, I think it's just interesting to see all of these cases in the media, them coming down different ways, some guilty, some not guilty. And I think we can see that at this point, and I got some hate for saying I think the criminal justice system is working in these situations. I think that they're looking at the case, they're trying to analyze the facts that are put in front of them, and they're trying to come down with the decision they think is right. Because I'm sure there were people on both sides of the political aisle on both of these juries, on Rittenhouse and on Arbery. So
100%.
so what do you think as far as what that says? And sorry to everybody listening that doesn't want to hear about Rittenhouse tonight, because they were very interested in Rittenhouse when I was talking about it, when it's a Rittenhouse title, but it's Arbery. So let's just talk about a little bit what you think that shows as far as the jury system we have right now.
I always assume that a jury is comprised of 12 idiots. I'm not going to kid you. That's an assumption I'm walking in there. The 12, or I shouldn't say idiots, 12 midwits. That's what I assume that we're dealing with. And rightly or wrongly, that's just how I'm going to walk
It's
in there.
not always the case, but it can be.
Yeah, you know what? Maybe not 12 midwits, but like certainly 6 or 7 midwits, and maybe a couple of people who, yeah, who are politically motivated, or especially in the culture that we're living in today, where there's such a deep chasm between left and right that it's almost hard to not find yourself strongly aligned with one side of the aisle or another. So certainly when you get a dozen people together, it's almost impossible to find 12 people at random that none of them feel a certain political affiliation one way or another,
Right.
if not the majority of them. So that being the case, that does make you that would make anyone grow concerned as to whether or not they're assessing the facts, seeking truth, or whether they already have a preconception about the truth, and now they want to find facts that feed their narrative that they've already walked in here with, or that they decided 3 minutes into the trial. So this is, to me, this is very encouraging. I will say this: the Arbery case is really unique. It's really, really unique because I think it's one of the first times in the last couple of years that I can remember. I think both left and right wanted to see him get convicted. I think the whole world was against them. By the time the trial concluded, certainly, I mean, look, I'm definitely aligned with far more with conservative perspectives. I'm sure everyone on the left was screaming to cut their heads off, and I'm sitting here on the right, and I was rooting for them to get convicted. I was like, these guys, I don't think Arbery was any kind of saint. I think he was probably a burglar, and he had actually, if you look into his history, he has an MO of doing exactly what he did that night in other places, or that day in other places, of robbing and pretending he was jogging. And I'm sure he was trying to burgle the place. And I'm also equally sure he didn't deserve to die for it. So, and these guys, what they did, it was very foreseeable, and they deserve to be appropriately punished for it. So, and I'm pretty far right leaning. And so I'm agreeing with the left that these guys deserve to be locked up for a very long time. Where do you ever see a situation like that today? Anywhere in society where that left and right are all united on one thing and relieved by the outcome and saying, thank God. So
Yeah,
In that
and I
sense,
hope
I think that's reassuring. I don't know where you stood on it. You sounded like you felt they were guilty all along, from what I've taken from you so far.
I did. Yeah, I did. And I kind of mentioned that before the trial even thought or started, that I did think they were guilty. Again, I don't know to what level for each of them.
Right.
But yeah, I definitely thought it's just one of those things, like you say, with gut. Like, you just don't do that. You can't do stuff like that. We don't want to send a message to society that this is how you should handle somebody running through your neighborhood that you think may have been in your neighbor's house. Like, that's just not how we want to handle society. Now, call the cops every single time, and report it. If you film him running down the street on your camera, send it to the cops so they can go catch him and arrest him, and he can get convicted of burglary if that's what he was doing.
Can
That's
I
what we
share
want
with
to
you
promote.
something? Can
Sure.
I on that line, because I mentioned I almost dropped as a tease earlier as to how they changed the law in Georgia and how far they swung the pendulum in the exact opposite direction. Under the new statute, as is in law of self-defense, if someone breaks into your home in Georgia today, and that was not the case back then, 2 years ago, but today, someone breaks into your home and you keep them there, and you say, you call the cops and you train a gun on them or whatever, you lock them in the house, prevent them from escaping, you have just committed a crime of false imprisonment. You must allow them to run away. If you do not allow them to run away when they know when the cops are coming, you have now committed a crime of false imprisonment. And in fact, as we're discussing here, if something happens to them after you falsely imprison them and they drop dead, you just did the same thing. You convicted for the same crimes that the McMichaels are convicted for. You just committed felony murder, because there's a felony of false imprisonment when you don't let the burglar get away, and he's dead now. That's felony murder. So that's the way it is in Georgia today as a result of this incident. And that's a horrifying thing, because you can easily foresee someone catching a burglar in their house and calling the police, and the next thing you know, something terrible happens. There's a wrestle for the gun, the guy fights with him for the gun, and the next thing you know, this guy is under Georgian law culpable and can go to prison for the rest of his life. That's
So
horrible.
you can't shoot an intruder when they come in your house anymore in Georgia?
If they're not falsely, if you're not imprisoning them and you're trying to protect
Right.
yourself, your
You can still
life,
shoot
or
them?
the life of others, yeah, you still have
Okay.
self-defense. Yeah,
Yeah.
but you can't try and keep them there for the police to come, and that's crazy. I'm sorry.
It's
You're better off
interesting.
shooting them right. You're better off shooting them right away and say
Yeah.
they were charging at you, than having a situation where you have on tape that
I
somewhere.
always wonder what lawmakers think. Like, do they understand that that's now promoting just shooting someone as soon as they cross the threshold? Because that's what it is. That's for people that are big Second Amendment gun guys and gals. Now they're just thinking, fine. Now the law says I got to shoot you as soon as you walk in my door, which is problem. I mean, I'm not for.
I'm
Listen,
not
I'm not a big tough guy who's going to try to make a burglar come. If he runs out of my house, that's probably what I want anyways. I
right.
got a gun in my house and I'll do it to protect my family, but I would rather him leave than me, keep him here for the cops. But like you're saying, that doesn't make any sense that you can't make sure this guy gets arrested after he just did the one thing that's supposed to be sacred in the castle doctrine, and not break into your house with your family and your kids and your, everything there,
Yeah,
violating that safety that you have. I mean,
it's the
it's
ultimate.
going in a weird direction.
It's bizarre. I will tell you this, and I don't make a penny from this. In fact, he has no idea I'm doing this right now. But over the last couple of weeks, I managed to learn a lot from Andrew Bronco Esquire, who's goes by Law of Self-Defense. In fact, you can find him at lawofselfdefense.com. If you own a gun, and God forbid you're in a situation where you feel like you're forced to use it in self-defense, that might help save your life. But if you don't know the law, you really can be facing serious issues like Kyle Rittenhouse did, or the McMichaels here. You want to end up being acquitted. You really want to know the law. He sends his book away, I believe, just for the price of shipping and handling. So it's lawofselfdefense.com. I make zero from this. I don't get a commission. There's not even a promo code because he has no idea I'm doing this. But I highly recommend it
Do
to
you
any of
have,
you who have a gun.
did you do a video with him on your page?
I had him once last week. So he came on for a live stream, and this is where he informed me about the change in Georgian law. He actually had a lengthy debate with Nate the lawyer on my stream, and I pretty much sat there watching them argue out the law in Georgia about this Arbery case. So
people are asking in the chat about it. So go to Joe's page, subscribe to Joe's page if you don't already. Check out that video.
Yeah, the thumbnail there, the thumbnail for that actually has a picture, I think, of Chuck Norris, and I call him I call him Andrew Branca, the Chuck Norris of self-defense law, which I thought was I was very proud to come up with that title. So
because a bunch of people are asking what that bill is, where they can find it, where they can learn more about it. So go to Joe's page, check out that video. You'll get the info there. You'll get the guy's info that does it all, and you can reach out for his book potentially. So
if you're gonna sub to me, I really urge you this, and this I mean seriously, because of my political affiliation, YouTube really does not like me, and I literally can go to sleep and I'll see that I have 20,600 subs, and I wake up the next morning and I have 20,100. It's like people just get scrubbed away. So if you're going to invest the effort to subscribe to me, I strongly urge you to hit the bell that you're getting notifications, because those people tend to actually stick around long enough to get notifications from me. And I really appreciate. This was great meeting up with you. This was really
it was fun.
Yeah, it was fun. You're good. You're a good chat. You're a good schmooze.
I appreciate it, man. Yeah, I've never done. You're the first lawyer I've ever talked to on YouTube. Like,
get out of here. I'm it.
Outside of my firm, I've only had other lawyers in my firm come on and talk about what they specialize in and do. Yeah, Can I get you to come on my show sometime? Absolutely. Yeah, this was really fun. I would like to do it more. I've never done it before. People put some lawyers in my chat to reach out to, so we reached out to them, and it was a lot of fun. I'm really glad we were able to do it, and I really, really appreciate you coming on, man.
It was totally my pleasure. Thank you so much for having me.
All right, that's it, folks. Appreciate it.
Ciao.